So there's some progress and some hindrances.
Yes, my lord. Efforts are going on, my lord, to resolve whatever impediments are coming up.
My lord, they have, in terms
How
of
many trees have been felled now so far? 103.
But as per the last affidavit we filed, my lord, there are total 103 trees identified, my lord, and 63 trees by then, my lord, in the month of March were felled. And because this is a part of package 1, my lord, the earlier contractor has abandoned the contract, so we re-tendered, my lord, in the month of January. Till the closing date of 30th of March, my lord, 15th of March, the only one bidder came forward, my lord. So we had to re-tender it. And now it appears I came across the news items, my lord, the tender has been awarded recently, my lord. So, my lord, a week's time is granted.
But the other problem with this magnetic authority, how is that going to be resolved?
But that remains, my lord. Some land hindrance also remains, my lord, in the package 1 also.
Because that is right on the road.
My lord.
And there's no road on the other side.
My lord.
It's the cut on the other side.
My lord.
So if a part of it is not given, then and that is not an easy resolution.
My lord. That remains, my lord. But as far as the flyover part, my lord, where the trees are concerned, my lord, it appears that the tender has been awarded now, my lord.
Very well. We'll record that.
My lord. My lord, I'll have a proper instation. I'll file an affidavit in 1 week's time is granted, my lord. It appears package 1 and package 5 both where the contractors left the work, my lord. Package number 3 work has not even started till now, my lord. The Peninsula stretch.
And what about 2 and 4?
2 and 4 work is going on, my lord.
2 we find substantial work has gone.
And 4 also it is going on at the right pace, my lord. So problem is 1, 3 and 5.
Though the initial grievance of the petitioner pertained to the felling of trees for the construction of a flyover between Rilbong and Jalupara as a part of the Shillong-Dauki Road project, the matter has been since the scope of the matter has since been widened to look into the progress of the Shillong-Dauki Road, since it is essential not only for connectivity but for development in the state. Full stop. Paragraph. A lot of the other road construction projects are linked to the Shillong-Dauki project, in the sense that the identification of necessary bypasses, need to widen ancillary roads, and to provide a link to the highway that turns left from Umiam and carries on through Chowai, now bypassed within bracket, and Clariot into the Barak Valley and Silchar. Full stop. Paragraph. The latest status report on the status of the project as on May 24, 2023 reveals that work in respect of packages 2 and 4, 2 and 4 or 5?
2 and 4.
2 and 4
2
is
and
going
4
on.
of the Shillong Dauki project containing 5 packages is going on in right earnest, but the contractors who had been awarded package 1 and package 5 have abandoned the work, and the retender process initially resulted in a solitary bid being received for tender 1, for package 1, though now upon at least one further bid being received, the contractor in respect of package 1 has been identified. Full stop. This aspect of the matter is not referred to in the status report, but is submitted on behalf of the National Highways Infrastructure Development Corporation Limited. Full stop. Paragraph. It is further submitted on behalf of NHIDCL that there is no progress in the work pertaining to package number 3 and package number 5. Full stop. The several disputes, the several impediments in the work being taken up in respect of such 2 packages have been detailed in the status report. Full stop. They relate, mainly, to the local landowners not being willing to part with land, or disputes having arisen regarding the area of land necessary and the compensation therefore. Full stop. Paragraph. In particular, there is a serious dispute, serious problem that has arisen with what is that thing called? With the Indian Institute of Geomagnetism, which has a large tract of land allotted to it to the left of the road as one approaches Upper Shillong from the Rilbong area. Full stop. Such institute complains that the widening of the road would affect the magnetic records, the fragile magnetic records maintained in the institute. Full stop. However, the problem is that there is no road on the other side, and unless the institute agrees to part with some land, there can be no widening of the road on the relevant stretch. Full stop. Paragraph. It is hoped that NHIDCL and the National Highways Authority of India will approach the appropriate union ministry under which the said institute falls, and persuade the institute to part with sufficient land for the widening of the road on such stretch. Full stop. The state government should assist the NHIDCL in resolving the issues pertaining to acquisition of land and payment of compensation in several of the other areas. Full stop. Paragraph. NHIDCL, however, submits that since the contractor in respect of package 1 has been identified and the construction of the Rilbong to Jhalupara flyover falls within such package, the work in such regard may be undertaken expeditiously upon felling the remainder of the trees identified. Full stop. As of now, about 63 trees have already been felled. Full stop. Once the project gets off in right earnest, in respect of package 1, the remainder of the trees required to be felled may be felled upon planting adequate number of plants and ensuring their maintenance at least for a period of a year. Full stop. Let a further status report be filed when the matter appears next 6 weeks hence.
6 weeks.
Yes.
Item number 2.
May it please, Lordship. This is the teacher's matter, my lord, regarding disqualification. My lord, the government has come out with the policy decision tinkering the earlier rule, which also created bar for the teachers of the aided college to participate in the election. Earlier rule provided, my lord, that they could participate, there is a bar, but proviso provided that they can participate in election and hold offices of political parties, subject to the teachers getting leave and permission from the authority, my lord. Rule 6 created bar, Rule 6 proviso permitted, my lord. Rule 7 laid down the conditions, my lord. By amendment, Rule 7 has been omitted from the rules, my lord. Now, this was challenged by the petitioners, my lord, and two grounds were basically primarily urged, my lord. One is, my lord, that the teachers are getting salaries and they are holding office of profit by virtue of Article 191 because they are receiving aid from the government, and so therefore they are barred by the principle of office of profit under Article 191. Second principle was, my lord, that the teachers of the aided college and even government colleges are barred from participating in election, and the policy objective which led to change in the rule, my lord, is that
No, as a general rule, are teachers in universities or professors in universities
yes, Captain.
barred from conduct a standing for election?
In government employees are barred, my lord. So those teachers who are in government colleges, they are barred, my lord. Government employees, they have to resign and then they have to contest the election. I was having similar issue in my mind. I tried to check the UGC guidelines on this issue, my lord. UGC guidelines says that full-time employment, my lord, and the nature of employment which has been prescribed under UGC guidelines hardly leave any scope for the teachers to go for joining political parties or to contest the election, my lord. That UGC guidelines have also seen workload and those things, my lord. I will place them first, my lord. I will place the rules.
No, before that, previously they could obtain leave and it would definitely be leave without pay.
Yes, lord.
So what is the problem in that?
Your lordship,
It's going to be leave without pay now also.
there are two aspects, my lord. If your lordship would see the rules at page 42 of the page 42, my lord. And rule is at relevant rule is at page 46, my lord. Rule 6 at page 46, my lord. No employee shall offer himself as a candidate for election to a legislative body or for holding office of any political organization except in accordance with the provisions of Rule 7. Provided that an employee may seek election as an independent candidate of a panchayat with the previous approval of the managing committee, as the case may be, but he shall not be entitled to accept any office thereunder except in accordance with provisions of Rule 7. 7. Any employee desiring to seek election to legislative body or to hold office of any political organization or local bodies shall be compulsorily leave without pay from the date of filing his nomination till the announcement of result by the proper authority and shall be eligible to rejoin the post immediately. In case he is elected, he shall be on compulsory leave without pay from the date of filing his nomination till the termination of his office to which he is elected. Such elected employee shall be allowed to retain a lien on his post for a period not exceeding the full term of the elected body to which employee is so elected. In the event of such employee joining the post against which he had lien, the interim period of absence or compulsory leave will count for notional increment benefit or pay from the date of such rejoining. So the amendment which was carried out, the rules deleted, my lord.
Now tell us, what is the situation in respect of a government employee?
Government employees also, my lord, there is a service rule which clearly bars them from participating in the election, my lord.
But does it give them to go without pay and do it?
No, your lordship, because they can't join the political parties. Our government service rules bar them from joining political parties.
So Meghalaya rules or
Meghalaya rules, my lord.
CCS rules?
Meghalaya rules, my lord. And even in CCS, CA rule, classification control rules also, my lord, they are barred from joining political parties. So the issue which falls for your lordship.
What is the Office of Profit clause?
Office of Profit is in Article 191, my lord.
Yes, please.
A person shall be disqualified for being chosen as and for being a member of Legislative Assembly or Legislative Council of State if he holds any office of profit under the Government of India or the Government of any state as specified in the first schedule other than office declared by the Legislature of State by law not to disqualify its holder. So under the office of profit, what Learned Single Judge has held, my lord.
Now, as long as a government servant no longer draws salary, he can't be said to hold office of profit. Is there any provision where a government servant may obtain leave without pay and then have a lien over his post and then contest election, succeed, serve the tenure? After his severance with the legislature,
Yes.
he comes back and then
Joins.
joins.
My lord, there is no such provision for government servant. He has to resign and then he can join the political parties or contest election, my lord. There is no lien. Lien is only in cases of deputation or certain transfer, etc., outside the cadre, my lord. So whether it's government of India service or service of a state, my lord. But your lordship, the only issue is not payment of salary, my lord. The control is also a factor which your lordship, control, appointment, service rules, all these factors have been taken.
Control appointment service rules?
Your lordship holds any office of profit. Now the one of the parameter is payment of salary by the government to the employee, my lord. The other parameters are, my lord, the appointment, approval of appointment. This issue came for consideration before the Honorable Supreme Court in identical case in Bihari Lal Dohre, my lord. In that case, it was issue of appointment of teacher in a school, my lord. And there the Honorable Supreme Court laid down various tests. And based on that test, it held that teacher who is employed as a primary school teacher is holding the office of profit, my lord. So I rely on that judgment also in support of Article 191, my lord. What learned single judge has held that the appointment is not directly by the state government. Appointment is approved by state government. The salary is also not directly paid because state government gives grant to the management, my lord. And management in turn pay the salary to the. So the learned single said that there is no direct payment or direct appointment. Therefore, the test laid down in Bihari, that judgment will not apply, my lord. With respect, my lord, the test is whether government exercises some control over the person who is employed in aided institution or not, my lord. So I am covered by that judgment also, my lord, to hold that. But coming back to the first issue, my lord, so far as in the laying down the rules are concerned, my lord, we have power to lay down the terms and conditions of grant, my lord. One of the conditions of the grant is that you should not participate or contest the election as long as you are employees of the aided college, my lord. That is the condition which we have. Now
when you give grant, do you give full salary of the
teacher? Yes, my lord. Entire salary is given by the state, my lord. Again, sanction post. Sanction post salary is borne by the state, my lord. So therefore,
and you approve the sanction post?
Yes, I approve. We approve the sanction. The state approves the sanction board, and even the management selects the candidate, and final approval is also given by the state government. So on both the grounds, my lord, so far as it is debatable, my lord, whether this clause 7 omission has got some nexus with nexus with the object it seeks to achieve or not, my lord. But this issue came up before cabinet, my lord, and cabinet took a policy decision, my lord. I just want to place that Meghalaya education policy of 2018 at page 63, my lord. Which was approved by cabinet on 21st September 2018, and cabinet at page 82, my lord, the relevant part.
Page
82, 63, the policy starts, my lord, Meghalaya State Education Policy, and the relevant page is page 83. And 83, middle of the page, my lord, 7.4.3, my lord. Government and government-aided college, university teachers will be barred from taking part in political activities and political association. And in line with this decision of cabinet, my lord, the rule was amended at page 87. And rule 7 was omitted, my lord. in my humble submission, my lord, this policy has some basis, my lord. And third point, which my lord, which I have, my lord, is that teachers have no locus to challenge this decision, because I am covered by the judgment of the Honorable Supreme Court Constitutional Bench judgment on this issue also, because similar rule came to be challenged. In fact, same rule in Guwahati, my lord, and matter travelled to the Honorable Supreme Court before Constitutional Bench, my lord. So I have three grounds, my lord. First is that the policy has some nexus with the object it seeks to achieve, my lord. Second, my lord, the teachers are drawing salary from the state exchequer. Some certain sort of control is exercised. They are disqualified on the ground of office or profit. Third, my lord, that the teachers have no locus to challenge the condition of the grant. These are the three grounds, my lord, I urge before your lordship to consider. So far as the object, my lord, is concerned, your lordship is right that it is debatable, my lord. But the educational institution, in my humble submission, my lord, is a place which should be away from the political activities, my lord.
No, that need not be. We are not on that. We are on the fundamental point that you say is that office of profit, that when a person gets salary from the aid granted by the state,
Yes, Lord.
that would also be an office of profit.
Yes, Lord.
But the wording over here, he holds
Yes,
any
Lord.
office of profit under the government
Yes, Lord.
or under the space,
Yes, Lord.
under the state.
Yes, Lord.
So he does not hold any office
Yes,
under the
Lord.
government or under the state.
Yes. Now, your lordship is right that the petitioner does not hold office under the government, but this very term, my lord, has been interpreted in number of judgments by the Honorable Supreme Court, saying that there is no requirement to hold directly under the government, but if government exercises any sort of control, that will bring him within the ambit of office under the government. May I place this judgment, my lord, on dealing with this aspect, my lord?
Yes.
Is, my lord, 1984 1 SCC, page 551. If your lordship will see the paragraph 1, my lord. At page 554. The question involved in this appeal is whether an assistant teacher employed in a basic primary school run by the Uttar Pradesh Board of Basic Education constituted under Uttar Pradesh Basic Education Act 1972 is disqualified for being chosen as a member of Legislative Assembly under Article 191 1A of the Constitution. And then after recording the facts, my lord, paragraph 5, the object of enacting Article 191 1A is plain. A person who is elected to a legislature body should be free to carry on his duties fearlessly without being subjected to any kind of governmental pressure. If such a person is holding an office which brings him remuneration and the government has a voice in his continuance in that office, there is every likelihood of such person succumbing to the wishes of government. Article 191 1A is intended to eliminate the possibility of conflict between duty and interest and to maintain the purity of legislatures. The term office or profit under the government used in above clause, though indeterminate, is an expression of wider import than a post held under the government, which is dealt in part 14 of the Constitution. For holding an office or profit under the government, a person need not be in the service of the government, and there need not be any relationship of master and servant between them. An office or profit involves two elements, namely that there should be an office and that it should carry some remuneration. In order to determine whether a person holds an office or profit under the government, several tests are ordinarily applied, such as whether government makes an appointment, whether government has the right to remove or dismiss the holder of the office, whether government pays the remuneration, whether functions performed by holder are carried on by him for the government, or whether government has control over the duties and functions of the holder. Whether an office, in order to be characterized as an office or office under government, should satisfy all these tests, or whether any one or more of them may be decisive of its true nature, has been subject matter of several cases decided by this court, but no decision appears to lay down conclusively the characteristics of office or profit under the government, although the court has no doubt determined in each case whether particular office involved in it was such an office or not, having regard to its features, my lord. So after, and then, my lord, paragraph 12, in the facts of the case, my lord, in the light of the above pronouncement, we shall proceed to examine this case. There is no dispute the respondent was holding the post of an assistant teacher in a basic school on the date of his nomination as a candidate at the election in question, and was in receipt of salary attached to the post. The only question which needs to be examined is whether the post he was holding was one under the state government or not. This leads to us to consideration of relevant provisions of the Act, Uttar Pradesh Basic Education Act, my lord. And the provisions have been examined, my lord. And paragraph 20, my lord, where the petitioners are identically situated. We are of the view that present case is governed by principle laid down in the judgment of Raman Lal case of Lal Soni case. Function of the employees of the board are in connection with the affairs of the state. Expenditure of the board is largely met out of the monies contributed by state to its fund. Teachers and other employees are to be appointed in accordance with rules by officers who are themselves appointed by the government. Disciplinary proceedings in respect of the employees are subject to final decision by state government or other government office, as the case may be. In this case also, my lord, the salaries are largely met by the state, my lord. Their removal, disciplinary proceedings are controlled by the state, my lord. And they are to be appointed in accordance with rules also, my lord. So, all the features, all the tests which have been laid down in this judgment, Bihari Lal Dohre judgment, my lord, squarely applies to the facts of the case, my lord. Because it is a post, and post is carrying remuneration, my lord. Therefore, on the ground that the teachers are holding the office of profit, my lord, they are not eligible to contest election for the legislative assemblies, my lord. And there is another constitution bench judgment, my lord, State of Assam versus Ajit Kumar Sharma. In that judgment, my lord, the issue was whether teachers are entitled and competent to challenge the conditions of grant or not, whether they have locus or not, and constitution bench held, my lord, in respect of same rule, that teachers have no locus to challenge that also, my lord. May I place that judgment also, my lord? Paragraph 1, which this is an appeal by special leave against the judgment of Assam High Court. Sri Ajit Kumar Sharma is a teacher in the Girls College at Guwahati. He filed a writ petition in the High Court on the following government. This is a private college teaching up to BA standard and affiliated to Guwahati University. The college is managed by a governing body according to the provisions of the Statute of the Management of Private Colleges framed by Guwahati University under 20G. Under Section 23H, the Executive Council may frame ordinance to provide for emoluments and conditions of service of teachers of the university, including teachers of private college. University has, in pursuance of the powers so conferred on it, framed rules for grant of leave to teachers of private colleges, which are binding on the governing bodies, and had actually adopted by governing body college in July 1956 for its teachers. Under these rules, the governing body of college cannot compel a teacher to take leave without pay. The college receives grant in aid from the state of Assam, and there are certain conditions for giving grant in aid. These conditions do not provide for withdrawal of the grant in aid if a private college fails to put a teacher who seeks election to a legislative body or local body on compulsory leave without pay from the date of filing nomination till the end of next academic session or till expiry of the term of the office in which teacher is elected. Respondent, as already stated, is a teacher in the college. He applied for leave without pay from January 2nd, 1962 to March 5, 1962 in the order to contest the election in Parliament. Leave was granted to him by the governing body of the college by resolution number 1 March 9, 1962. The respondent stood for election and was defeated. He thereupon applied that he be granted to rejoin his duties from March 6, 1962, and the governing body permitted him to do so by resolution dated March 9, 1962. He therefore worked as such instruction. Assam director wrote a letter to principal and secretary college with reference to the letter of March 10, 1960 from the college in which apparently the director had been informed of the leave granted to respondent and certain other teachers in connection with election to Parliament and Assam legislative body. In this letter, director informed the college that he was unable to approve the resolution of governing body permitting the respondent and certain other teachers to rejoin their duties immediately. Later pointed out that such permission was in contravention of Rule 7 of the rules regarding conduct and discipline of the employees institution and could not therefore be approved. The director also added that rules had been framed in 1960 after due consultation with University and Assam College of Teachers Association. So Rule 7, my lord, came to be challenged by the teacher, my lord. And the writ petition was allowed, my lord, by the Honorable High Court. And then in paragraph 9, the Honorable Supreme Court, after examining that these are the executive instructions, my lord, in paragraph 12, it returned the finding, my lord, the Honorable Supreme Court Constitution Bench, my lord. The main question which falls for a decision in this appeal is whether the High Court is right in issuing a writ of mandamus to the state. Paragraph 12, my lord. Paragraph 12, my lord.
No.
The main question which falls for decision.
That's not paragraph 12. Paragraph 12 is we main this question. The main question is paragraph 11.
Yes, my lord, sorry.
What are you looking? You're looking at something?
Same, probably not booked my SCC online, sorry, some.
This is AIR.
Yeah, yes, I'm sorry, I'm having SCC online. It starts from, my lord, the main question which falls for decision in this appeal. If you notice, the paragraph starts with the main question. In the middle of the page, my lord, if I place, my lord, there is, however, no law to prevent the state from prescribing the condition of such grant by mere executive instruction which have not forced the statutory rule. In the present case, rules have been framed in order to give revised grant to private colleges to enable them to give higher scale to pay. Rules have been held by High Court, have no statutory force, and there is no dispute before us. In these circumstances, it is clear that rules are mere executive instruction containing conditions on which grant would be made to private colleges to implement the recommendation of University Grant Commission as to pay scale of teachers of private colleges. Where such conditions of grant in aid are laid by mere executive instruction, it is open to private colleges to accept those instructions or not to accept them. If it decides not to accept the instruction, it will naturally not get the grant in aid, which is contingent on its accepting the condition contained in the instruction. On the other hand, if the college accepts the conditions contained in the instruction, it receives the grant in aid. If, however, having accepted the instructions contain the conditions and terms, college does not carry out the instruction, government will naturally have the right to withhold the grant in aid. This is, however, a matter between the government and private college concerned. Such conditions and instructions as to grant in aid confer no right on teachers of the private colleges, and they cannot ask that either a particular instruction or condition should be enforced or should not be enforced. It is only for the governing body of college to decide whether to carry out any action contained in mere administrative instruction, laying down conditions for grant in aid. Further, it is open to the government body not to carry out any such instruction which is not based on rules having statutory force. It will then be naturally open to state to consider what grant to make. But if the governing body chooses to carry out the instruction, it could hardly be said that instruction was being carried out under any threat. It is certainly not open to a teacher.
This is still good law.
Your Lordship, this is a constitutional bench judgment. It is still being followed, my Lord. The law has departed. Your Lordship is right that now the taste which was laid down then and now there has been change, my Lord. But the rule is same rule, my Lord.
This is good law.
The rule is same, my Lord. Rule is same, and same rule came for interpretation, my Lord.
Just because it is non-statutory does not mean that it must be challenged.
Yes, no. No, I am not on that part, my Lord.
Yes.
May please, your lordship. Lordship, what my learned just submitted, my lord. Here main question is, my lord, that whether the government aided college teachers or employees are under the government or not, my lord. Main question. As
That is not the main question. Main question is whether the salary that they get can be seen to be office of profit or not.
my lord, in my humble submission, my lord, it does not fall under the office of the profit, my lord. As the grant which was given by the state government is a duty of the state government, my lord, to maintain the educational institution. Here, my lord, the maintenance, appointment, and every maintenance has been done by the government body, my lord. Government has got no hand in maintenance of the institution, my lord.
Things. Indirectly, it comes as office of profit. The second thing is that the government imposes a condition for providing aid. If that condition is not found to be unreasonable, then how can that be challenged?
Well, here in this,
In a case of a government servant, in case of a teacher in a university
my lord,
or a professor or someone who's directly under the government,
my lord,
it becomes an office of profit.
my lord.
Over here, indirectly also, it becomes an office of profit. Because the pay scale and everything is decided by the government while granting grant. While giving the grant, it has to be against a sanctioned post. The government will check how many teachers are required and then will sanction the number of posts. And for the sanctioned post, the teacher will be getting at a scale not according to the whims of the college, but according to what is set down by the government. So it becomes indirectly an office of profit. More importantly is that if this is a condition that the government imposes, can that be said to be arbitrary? Because similarly placed persons who are directly under government service in government colleges and universities
My lord,
have the same restriction.
my lord.
So this restriction extended to government-aided colleges may not be arbitrary.
My lord, here, my lord, there is no condition which has been agreed by the government body. There is no agreement or has not been imposed.
No agreement is necessary. The government prints a set of rules and it says that will apply to all government-aided colleges. And in the absence of that, the aid will not be given. Now, you the teacher, you are challenging that condition which is imposed on the college. That condition is not imposed on you, the condition is imposed on the college.
No, my humble submission, my lord. My lord, this has been imposed stating that the government aided school teachers or professors and employees, my lord. It is directly, my lord, is concerned to the employees as well as the professor, my lord. This
will be confined to, this applicability of the rule will be confined to the sanction posts for which aid is given by the government. Mr. Advocate, that is right?
Yes, right.
Now, if let us say they have sanctioned 10 posts, if you occupy one of those sanctioned posts, you cannot do this. But if you are not in a sanctioned post, then you are there, then you can go away. The rules won't apply to you.
But my lord, there are. I would like to file the compilation of the various reasons, my lord.
The matter has been waiting for a long time.
My lord,
It has been waiting for a long time. We had heard the state, and every time we're asking them for.
My lord, that what the decision, cited decision has been
Size for that, there is no adjournment which is which can be granted.
No, my lord, that's my lord, we have a compilation explaining the provision of the profit of Office of the Prophet, my lord. My lord, as per Article 191, 192, and 102 of
Yes,
the
cite them.
article, my lord.
Cite them.
My lord, yes, that restriction, my lord, on the private schools, my lord.
Let us see the cite them.
My lord, I have to compile it in the appellate state, my lord. I'll need 2 days or 3 days time, my lord.
Very well. Then you have to repeat it, whatever you have done. Since the
My lord, I'm sorry.
respondents, one respondent.
2 respondents.
This is the respondent seeks some time to address the legal issues raised, comma, let the matter stand over for 10 days.
My lord,
Yes.
my lord.
Item number 3.
Obliged, Judge.
May we please, Your Lordship? Your Lordship, the conducting senior counsel is still indisposed. I beg to seek an adjournment of 3 weeks'
On
time,
the
Your Lordship.
ground of counsel being indisposed, on the ground of counsel for the appellant being indisposed, comma, let the matter stand over for a further 3 weeks.
Highly obliged, Your
Yes.
Lordship.
Item number 4.